All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores, Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
I am here, thank you. We will go ahead and start in a subcommittee of the Senate Judiciary Committee consisting of myself, Senators Hansen, Ellison, and Krasner until some more of our members join us. It is, again, that time of year where members do have to be in multiple places at one time, presenting bills, hearing bills, and taking care of other important business. So please don't take it as a sign of disrespect or a lack of interest that members may be joining us late or leaving early. But we do like to get started on time at 1 o'clock to give some semblance of control here in the legislature. And so I will go ahead and open the hearing on AB 90 and invite our presenters to the front. I know we have Assemblymember Moore here in Carson City, and it looks like we have Ms. Frazier down in Las Vegas. And if you could mark Senator Lang present, we will now already come out of subcommittee and meet in our committee as we've now reached a quorum. Please go ahead whenever you're ready, presenters.
Thank you, Chair and members of the committee. My name is Assemblymember Cynthia Moore, and CINTHIA-MOORE. I represent Assembly District 11 in the heart of East Las Vegas. I am pleased to present Assembly Bill 90, which aims to extend the Juvenile Justice Bill of Rights protections to children detained in regional treatment and rehabilitation facilities. Although I was not a member, this bill is a recommendation approved by the Joint Interim Standing Committee on the Judiciary during the 2023 to 2024 interim. During the meeting on April 26, 2024, Jennifer Fraser, Chief Deputy Public Defender, Juvenile Division, Clark County Public Defender's Office, presented to the committee on the need to amend the commitment process governed by Title V Juvenile Justice of Nevada Revised Statutes. Revising the process for committing a child to a facility will ensure consistency in the statute by requiring the same findings be made for both a delinquent child committed to a regional facility for treatment and rehabilitation and one committed to a custody of a state or local detention facility. This bill directly addresses these concerns. Now I'm going to go through the sections of the bill. Section 1 of the bill includes regional facilities for treatment and rehabilitation of children within the definition of detention facility for the purposes of the Juvenile Justice Bill of Rights. This expansion ensures that children in these facilities receive the same rights, protections, and information as those in local and state detention facilities. This includes, but is not limited to, the right to be informed of their rights, receive a copy of those rights, and have those rights posted conspicuously within the facility. Section 2 of the bill provides that before the juvenile court commits a delinquent child to a regional facility for the treatment and rehabilitation of children, the juvenile court must make the same findings required for committing a delinquent child to a state facility for the detention of children. These findings include determining that 1, appropriate alternatives that could satisfactorily meet the needs of the child do not exist in the community or were previously used to attempt to meet such needs and proved unsuccessful. And 2, the child poses a public safety risk based on the child's risk of reoffending as determined by a risk assessment conducted pursuant to NRS 62E.506. Any history of delinquency and the seriousness of the offense committed by the child. Assembly Bill 90 is a measured and responsible step toward ensuring the well-being of children within our juvenile justice system. By extending the Juvenile Justice Bill of Rights and reinforcing judicial oversight, we can better protect vulnerable youth and ensure appropriate placement decisions. I urge your support, and we welcome any questions. I do have Jennifer Fraser, Chief Deputy Public Defender with the Juvenile Justice Division with the Clark County Public Defender, down in Las Vegas to answer any technical questions you may have. Thank you.
Thank you so much. Do we have questions from members of the committee? All right, I do not see any questions, so we will move right into testimony on AB 90. Anybody wishing to give in-person support testimony on AB 90 is invited to do so now. We will go ahead and start in Las Vegas. Oh, okay. So no one here to give support testimony? Okay. Let's go to the phones for support on AB 90.
If you would like to testify in support to Assembly Bill 90, please press *9 now to take your place in the queue. Chair, public line is open and working. However, there are no callers at this time.
All right, then we'll go to testimony in opposition to AB 90. Anybody wishing to give opposition testimony in person is invited to do so, but I don't see anybody coming forward. So we'll go to the phones for opposition testimony on AB 90.
Chair, the public line is open and working. There are no callers at this time.
Okay, we will go to neutral testimony. Anybody wishing to give neutral testimony is invited to do so now. I don't see anybody coming forward in Carson City or Las Vegas, so we'll go to the phones for neutral testimony on AB 90.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of testimony, and if the sponsor has any closing remarks. All right, that brings us to the end of our hearing on AB 90. I will now close this hearing and open the hearing on AB 518.
Thank you, Chair. I'm Heather Goulding. I represent Assembly District 27 in North Reno, and today I'm presenting Assembly Bill 518. It would authorize the replacement of the Interstate Compact on the Placement of Children with the revised Interstate Compact on the Placement of Children. So this compact provides the legal framework for children that are being placed from one state into another state for foster care, for adoption, pre-adoption, or for placement with a non-custodial parent. The language which is enforced in the current compact was written in the 50s, and this is the need for a revised version of the compact now. The current compact is in effect in all 50 states. I just want to give you a quick illustration of what the compact does. So if a child is, in this case, there's a sending state and a receiving state. The sending state, a child needs a new home, and the caseworker in the sending state would prepare a requestment packet, and the information that's in that packet is identified in the current ICPC. So that packet then goes to a central location in the state, a central office in the sending state, that goes to a central office in the receiving state, which then goes to the local social worker where that placement is requested. There would be a home study in that location, and then it would reverse the path back to a central state, a central office, and then eventually the child would be placed. So this is ideally how it works. And this is the compact is then providing all the framework for each one of those steps. So the compact is needed because it ensures that there are uniform procedures for placing a child from one state to another, so that there's not a handoff and then a child is just good luck in the new state. So it ensures continued supervision. It makes sure that we've identified who the legal and financial responsible party is, and it would ensure if things go south that that child would return to the sending state. So what's the problem with the current compact? It's old, it's out of date, and we need some updated language. It lacks deadlines so that the little house where the home study was taking place in my little illustration, there's no timeline in the current compact that says this is how long that process should take. If a placement is denied, there's no procedure in place right now for challenging that denial. And when updates need to be made, just as we're doing right now, there's no easy way to update the language. So the solution is this revised ICPC. It was written in 2006, and it accomplishes several things. First, it modernizes the legal framework. And a key step to this is that the rules that will be established once there are 35 states that have adopted the new compact. There's a 12-month period in which rules will be established, including a timeline, so that there's some established parameters on how long it will take to do the home study. It clarifies the applicability to non-custodial parents. Right now, the courts can say, we're going to give the child to a non-custodial parent without doing this home study and making sure that it's in the child's best interest to be with that non-custodial parent. And there are cases in which that's proven disastrous. That also allows for some review of denials. It strengthens enforcement of the agreements, and as I mentioned before, it will allow some updates of the language so we don't have to go through this entire process for a new compact. If we don't do this, if we don't adopt this, and then we'll have some states that are using the old compact and some states that are using the new compact, and for that first 12-month period, there'll be some friction in which rules are standing, and complicates after that 12-month period of adoption, if there will be some challenge to whether we can actually place children in a receiving state that doesn't have the new compact in place, so we don't want to be in that position where we don't have the legal framework. And without this new compact, some children are held in foster homes when they could be in loving homes, and the current compact is just delaying good home placements. These are the 18 states that have currently passed the compact. We're waiting, so we need to get to 35 before it will be enacted. I'm going to skip through the walkthrough unless I get any nods from the chair, or we'll just do skip the walkthrough. And I've included a bunch of FAQs in the event that you all want to review those. I'm not going to walk through those FAQs either, but I am open to any questions. I do want to also let Senator Krasner know, you had asked earlier today when we spoke about the timeline. So there is no timeline right now that constrains how long it takes to do the home study in the receiving state. There isn't a set time right now. That's part of the parameters that would be established in the 12-month rulemaking process that would follow the adoption after 35 states have adopted the compact.
All right, thank you so much. I think we do have a few other questions. I'm going to start with Senator Lang.
Thank you so much, and thank you for coming to my office today to speak with me about this. So I'm curious, because only a few states, 17 I think you said, have passed this so far. So if we in Nevada were to pass this, would we operate under the new rules, I will call them rules, or under the current rules?
Thank you for the question. This is Heather Goulding. Until the compact is adopted by 35 states in total, and then that next year of rulemaking takes place, we will continue to operate under the current compact.
And then next we'll go to Senator Hansen.
Thanks, Madam Chair. Thanks for coming to my office as well. You're a very effective lobbyist for your bill, I might add. Assemblywoman Bacchus had a concern about, you mentioned the Indian tribes possibly. Did you have a chance to talk to her about that?
Thank you, Senator. Yes, I did speak with her, and I have to admit that her concerns, I am not able to translate those as effectively as she can. I think that she wants to make sure that there is not a conflict, and she had not had an opportunity to do a deep dive into this revised ICPC, but I don't want to misrepresent her position, so I will refer you to her.
Okay, very good. Just wanted to double check. Thanks, Madam Chair.
Next, we'll go to Senator Ellison.
Thank you, Madam Chair. And thank you. It was great to get to talk to you this morning. And I also got on the phone to call her office, and she was out. But I got to talk to the only no vote that was on there, and I asked him why. She explained to me because the federal law and the state law, she didn't understand. That's why she went ahead with a no vote. And I thought that was pretty good. She explained everything to me, which was really good. And the only question I had was on P, on page 5, and she helped me get through that too. But what it was it said corporation. It says means or private corporations, and I asked her why was it not done with our state agencies or the agencies down there. And what it seemed to be is that because it's across a different state line, it made it easier. Is that correct?
Heather Goulding for the record. Thank you, Senator. I think that the thing that that the ICPC is most relevant with child welfare cases and child welfare adoption cases, and sometimes the private adoption agencies are not using this framework. But if you need a more detailed explanation, I can call a legal friend.
Thank you. It seemed like I found everything I was looking for on the whole bill, and between you and your colleague, kind of explained everything. But it was kind of good to get on the phone and ask all them questions and get them all answered prior. So thank you.
All right, we'll go next to Vice Chair Flores.
Thank you, Madam Chair, and thank you for the presentation. I was curious to know if the compact, once we hit the 35 states, and I didn't see it, but I may have just missed it, does it speak to scenarios where you have a child that comes from outside of the U.S., we establish jurisdiction in State A, now we want to have jurisdiction in State B, they're coming into it, do we speak to that? I know there's issues with like the Hague Convention that has a lot of interplay, and it has a huge impact on immigration law specifically. So I was just curious to know if you've had an opportunity to see it through there, or does it completely gut out those specific type of scenarios where we're talking about a child that was not born in the U.S. I don't know if there's anything there that you've had an opportunity to look at.
Thank you for the question. Heather Goulding for the record. The compact does not apply to international adoptions or placements. You've got me in a position where that is over my head in a situation where a child is coming from international location, comes to the United States, and then is looking at a state to state, but I can get back to you on that. I can also do a quick check. We're calling a friend.
Appreciate it. Thank you.
For the record, Marla McDade Williams. I serve as the administrator for the Division of Child and Family Services in Nevada's Department of Health and Human Services. Madam Chair, through you to Senator Flores.
Oh, please go direct.
Okay, thank you. As I understand it, if we had a situation where a child was taken into the child welfare system who had a biological parent in another country, we would work with the consulate, we would work through those international means to work on those placements. So as the Assemblywoman said, the compact itself does not apply in that situation, but we would work within the international law to assist with getting that child placed where their needs are best met.
Understood. And thank you. And I know we're not there now, but I was curious to know just how that would play, because we do have that scenario often. Child that comes into California, unfortunately, the parents are nowhere to be found. Sometimes you're having a hard time getting a family member. Now the state has taken custody over that child, and then eventually they get placed in Nevada or some other states. So I was just curious, but I really do appreciate what you indicated, and it makes sense what you're saying. Thank you.
Any other questions from members of the committee? I just wanted to get a brief clarification on the transition process. So once 35 states adopt the revised ICPC, I understand there's a 12-month period of rulemaking, and then is the assumption that those last 15 states will also adopt it, or could we end up with a few outliers that never update?
Heather Goulding for the record. My understanding is that the hope would be that they will come on board, because the complication of not coming on board will be challenging enough that they there will be enough inspiration to join the club that they will. Do you want to add?
For the record, Marla McDade Williams. I think the challenge would be posed in that situation is that if they had kids, that they wouldn't be able to participate in the compact. So they would be looking at their own set of resources to ensure the safety and well-being of that child if they wanted to place in another state. If we, for example, were not able to do it, we would have to somehow have the resources to go to the state, do the home studies, ensure the safety of the child, basically almost have our own child welfare system in another state. So the feasibility of that, it makes it really hard for a state not to participate if 35 states do engage.
Thank you. And then just to kind of follow up, I'm not sure if you'd be able to answer this, but are there any states that have been resistant, that have rejected the compact, or is it just kind of, I completely understand that we can't pass a bill in 50 states at the drop of a hat.
Heather Goulding for the record. I actually spoke to the organization that is leading the charge here and that administers the compact. I asked them that very question today. Why 20 years so far, and is there a renewed emphasis right now to try to get this through more quickly? So the first thing is that there was a real economic crisis when this was starting, and so and that decreased the incentive to be dealing with the compact at the time. So that was one of the explanations why there was a stalled start to the program and adoption by multiple states. There's an increased emphasis right now because the old language is so outdated that there's a renewed push for fixing the broken compact.
All right, thank you so much. Unless there are any further questions, that'll take us to the conclusion of our presentation. Thank you again for presenting the bill and answering all of our questions. We'll now go to testimony in support of AB 518. If you'd like to testify in support in person, now is the time to come forward, and we will start here in Carson City.
Good afternoon, Chair Scheibel, members of the committee. For the record, my name is Cadence Matijevich, C-A-D-E-N-C-E-M-A-T-I-J-E-V-I-C-H, Government Affairs Liaison for Washoe County. Washoe County is here to urge your support for AB 518 for all of the reasons that you've heard from Assemblymember Goulding. The existing compact first adopted in the 1950s. Certainly things have changed since then. Nevada became a member of the compact in 1985, so we've been operating under this for many, many years. We do think that the changes are needed. Just for some context, when you look in the bill at some of the sections on definitions, you go all the way to a new definition, BB. The current compact, A through D. So there's a lot of definition and clarity that will be brought to place if this were to come to bear. And so I will make the plea to you that I made in the other house of let's get to 35 in 2025. Thank you.
Thank you. I don't see anybody else coming forward to give in-person support testimony, so we'll go to the phones, please, for support testimony on AB 518.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we will go to opposition testimony on AB 518. I don't see anybody coming forward in Carson City or Las Vegas to give opposition testimony, so we'll go back to the phones for opposition on 518, AB 518.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, then we will just do neutral testimony on AB 518. Again, not seeing anybody coming forward to give in-person neutral testimony in Carson City or Las Vegas, so we'll go back to the phones for neutral testimony on AB 518.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then unless the presenters have any closing remarks, that brings us to the end of our hearing on AB 518. I will now close the hearing and move on to the final item on our agenda, which is public comment. Anybody wishing to give public comments, invited to do so now here in person in Carson City or down in Las Vegas, but I don't see anybody coming forward, so we will go to the phone lines for public comment.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that takes us to the end of our meeting today. Just for clarification for our secretary, because I don't think I did a good job earlier with the roll today, we now have all members present except for Senator Orenshaw, who is absent excused. And I do not plan on having a committee meeting tomorrow. I do plan to have one on Monday at 1 p.m. And so until then, we are adjourned.